July 1st of 2025 saw some changes for employers and employees in Florida based on a new law that came in. It's called the Choice Act. The Choice Act did a couple of things, but the one aspect I want to talk about is how, for employers and employees, it has a big difference in how agreements to not compete are handled. So what used to be under Florida law is that most times there was a limit of 2 years that a company could require an employee or former employee to not compete. Now that's been extended out to possibly 4 years, doubled, but there are some additional provisions. One of the provisions is that employees get at least a week notice so they can consider the agreement. Another important provision is that an employee has to receive a certain minimum salary. That salary is going to be based on twice the mean salary for the county in which you're working. So if you're in Dade County, for instance, where I'm at, and the mean average salary, I don't know what that is, but let's say it's $60,000. That means that in order to be subject to a non-compete, you'd have to get a salary that's at least $120,000 a year. Those are a couple of the more significant provisions of the Choice Act relating to non-competes. So if you have non-competes that your company normally rolls out to its employees or independent contractors, you're going to want to take a look and make sure that you're complying with the new law and whether you can enforce those. On the flip side, if you're an employee and you're presented with one of these non-competes, it's worth talking to a lawyer to see whether it's enforceable and to what extent.